Okay, so everyone listening at home, welcome to our last tutorial for the semester. It's gone very, very quickly. As I have foreshadowed in earlier tutorials, the way that this one will work is I'm going to go very carefully through particularly question 1 of this tutorial because it is a past exam question, and we'll also go fairly carefully through the second question as well as quickly as time allows us, before having a little bit of a unit review session at the end. So hopefully you'll enjoy it. You can strap in for a very exciting tutorial as we work through this enormous question. So now that we are in exam mode, very much in exam mode, because the exam is a week away, the first overarching issue that you need to consider, as we have done in previous tutorials, is whether Part 1 of the Electoral Future Act is supported by a subject matter of legislative power in the Constitution. So again, in the exam, the presence of an Act of Parliament or legislation is a clue that you need to look at the legislative powers of the Commonwealth Parliament. Okay, so we have legislation on the facts of our question. Now, I think the most logical way to approach this question, and the same goes, if it was an exam question, is to go through each part of it really systematically. That way you won't miss any of the issues that might be hidden in the different parts of the legislation. I should say as well, and you probably know this, I think I might have said it before, what we're doing when we ask this really broad question, we're engaging in the process of characterisation. We're trying to match up this piece of legislation with power, with legislative power in the Constitution. That's what we're actually doing. So hopefully you'll recall, it was a little while ago now, it was in tutorial 3, we looked at this broad topic, and we found that the Commonwealth Parliament does have power to make laws providing for the qualification of electors or voters for the House of Representatives and the Senate. This is known as the franchise. And we know that from the decision of Roach and the Electoral Commissioner, and I've put the relevant provisions on the slide for you. We also know that the Commonwealth Parliament has power to make laws relating to elections, in particular the election of senators and members of the House of Representatives. So that is the combined effect of all of the provisions that I've listed on the slide for you. Okay, so I really advise maybe have another look at what we covered in tutorial 3 as well. This really should just be a recap of that. So is everyone with me so far? So what I've done here is I found some provisions in the Constitution that give the Commonwealth Parliament to deal with these subjects, basically. Is everyone all right? So that's a pretty straightforward issue. Now, hopefully, again, you'll remember that both sections 31 and section 5136 contain the words subject to this Constitution. So again, that's sort of like a code because that phrase is understood as meaning subject to any limits that are imposed by the Constitution. So hopefully you'll recall from the very, very first tutorial that we had that in Australia we have constitutional supremacy rather than parliamentary supremacy like they have in the United Kingdom. Or even the states here really have parliamentary supremacy. So that means the power of the Commonwealth Parliament is always subject to constitutional limits. And that's why it's so important that we always consider whether there are any limits on that legislative power. So the High Court has held that the constitutional requirement of directly choosing our representatives, as set out in sections 7 and 24, establishes this really important principle of representative government. And the High Court has relied on this principle of representative government to limit the power of the Commonwealth Parliament to pass laws that restrict political communication. Okay, so remember, it's from representative government that we have this implied freedom of political communication, which is a limit on power. That's not relevant for this part of the question, I'm just saying it for the sake of completeness. What is relevant for our question is that representative government has also been used to limit the power of the Commonwealth Parliament to pass laws that restrict the voting franchise and electoral enrolments. Okay, and the authority for that are the decisions of Roche and the Electoral Commissioner and Rowe and the Electoral Commissioner. So I just want to pause there and just sort of summarise what I've just said. It's really important that this broad principle of representative government or representative democracy has been relied on by the High Court to restrict the power of the Commonwealth Parliament to pass laws that A, infringe or restrict political communication, and B, laws that restrict the voting franchise and electoral enrolments. It's this principle of representative government that's such an important source of these limits. So, having established that the Commonwealth Parliament does have power to make laws relating to the franchise and relating to elections, the next important issue that we need to consider is whether there are any express or implied constitutional limits that apply to Part 1 of this Act. Okay, so this should be becoming a fairly familiar process when you go through legislative power. So in particular, the main issue that we're concerned with is whether the impugned provisions in Part 1 unreasonably restrict the voting franchise. That is the key sub-issue that we need to work out. This part of the question, this is not an implied freedom question. This is all about the franchise. So let's have a look and go through each individual provision. And again, if this was an exam question, this is exactly how I would recommend that you work through a question. I think it's really important to break it down into parts or sections because then it's less overwhelming for you and you won't miss those issues. So if we work through Section 10, what Section 10 does is it extends the franchise or the vote, extends the vote to include persons that are aged 17 years old. Now, that is compatible with the constitutional requirement of choice in Section 7 and 24. And the authority for that, as I have on the slide is McKinley. McKinley's case is a good authority for that, but also some cases that we've already looked at. So you could also cite Roche and Rowe as well to support that proposition. I just want to talk briefly about McKinley because there are just some really good quotes that really, I think, sort of explain this area really well. So you can take these down if you want. It's probably not super necessary for your exam, but yeah, I'll say them slowly and let me know if you need me to repeat them. So in McKinley, McTiernan and Jacobs took the view that the long-established universal adult suffrage may now be recognised as a fact. So I'll say that again. So that was McTiernan and Jacobs, Justices McTiernan and Jacobs in McKinley. And they held that the long-established universal adult suffrage may now be recognised as a fact. And they went on to say that it is doubtful whether subject to Section 30 of the Constitution, anything less than this could now be described as choice by the people. So that's a really important quote there, because what those judges are saying is that anything less than a universal suffrage, or as close to universal as we can get, anything less than that, it's doubtful whether it could actually satisfy that meaning of choice by the people. Another interesting judgment came from Justice Murphy, and he said a similar thing. So you don't really need to take this down. This is just to illustrate where we're at in Australia with the franchise. He reasoned that democratic elections necessarily required uniform adult suffrage, and any law of the Parliament that deprived persons of a right to vote on the ground of sex, race or lack of property ownership would be incompatible with the constitutional requirement of choice by the people in sections 7 and 24. Similar statements were made in the decision of Roach, and we discussed these particular statements in our in that third tutorial, okay, in week 5. So have a look at Chief Justice Gleeson's judgment in Roach. Hopefully you'll recall that he said the franchise is critical to representative government and lies at the centre of our concept of participation in the life of the community. And he went on to say that disenfranchisement of any group of adult citizens on a basis that does not constitute a substantial reason for exclusion from such participation would not be consistent with choice by the people. And similar observations were made by Justices Gummow, Kirby and Crennan in their judgments. The reason I'm giving you these quotes and these extracts, and I hope that you go and have a look at these cases, which we have told you to have a look at, is because the franchise is critical to representative government. That's the significance of all of these quotes. There's actually judicial recognition of the constitutional significance of the franchise. The franchise supports and enhances our system of representative government. There are some other cases where, I've listed them on the slide, in Nationwide News and Wills, Justices Dean and Toohey adopted a really similar position to the quotes, to the judges that I've just read out. And the High Court actually noted unanimously, in the case of Longy and ABC, that the Constitution provides for the fundamental features of representative government. So even though those words are not spelt out in the text, it's one of these very, very important principles that underpins the whole document, and the Court's been willing to read in limits on the legislative power of the Parliament, subject to representative government. Having said all of that, it's a very long way of saying that Section 10 is valid, and the reason it's valid is because it actually extends the franchise. It actually enhances representative government because it's giving more people a say in who they elect to represent them in the Parliament. But a really good answer would demonstrate knowledge of at least one of those cases that I've just been through. And an excellent answer would be able to point to some really good direct quotes from individual judges. Because remember, this is a subject where we don't always have unanimous decisions. We do have some, but it's really important to actually be able to draw on the reasoning of the majority, where it's really persuasive. Is everyone happy at least with section 10? So for those who've attempted the question, did you find you were happy to say that section 10 was valid? Yeah? For those listening at home, I'm seeing some nodding. This is excellent. I'd like to move on to section 12 though. Section 12 is an interesting provision. So as I have said on the slide, the practical effect of this provision is to prevent people from voting if they don't hold a driver's licence or a passport. So that means the practical effect of this provision is very analogous to the decision of Roe and the Electoral Commissioner. In that case, it diminished opportunities for enrolment to vote. On our facts, we're seeing diminished opportunities to actually cast a vote. Now, hopefully you remember from the decision of Roe that the rationale for the change relating to the closure of the electoral roll in that case was to ensure the integrity and accuracy of the electoral roll. So remember, that was the case about the early closure of the rolls, of the electoral roll, and it caught a lot of younger people. Here, the practical effect, as I said, of section 12, it's going to do the same thing. It's going to prevent people from voting because they have to have a driving licence or passport in order to receive a ballot paper. So the effect of this compulsory voter identification requirement is to essentially disenfranchise an appreciable section of the community, and on that basis, it intrudes too far into the system of voting. Now, if we look really closely at the facts of this problem question, this requirement to have a driving licence or passport applies to all electors. It doesn't just apply to the 17-year-olds. So it could disenfranchise potentially Indigenous Australians, people living in rural and remote communities, elderly people. So it's quite a significant number of people would be affected by this. However, particularly for the 17-year-olds, it's interesting because a person who is age 17 is not actually required to have a driver's licence or a passport unless you're desperate to go overseas. So it's I think there'd be a reasonable conclusion to be drawn here that this is arguably disproportionate to the benefits of the amendments in ensuring the integrity and accuracy of the electoral roll. And remember, again, you could draw on those judgments in the decision of Roe because the court found that the impact on young people was disproportionate to the benefits of a smoother and more efficient electoral system. And again, applying Roe to our factual scenario, we have facts that tell us that the rates of voter fraud are minimal. So we need to apply Roe because the impact of this law is significant in that it potentially excludes a lot of people from voting for a purpose that isn't really that significant, okay? So we have a proportionality issue here. It's a disproportionate restriction when we are told that rates of voter fraud are minimal. So in light of this fact, I think the provision lacks a substantial reason for restricting the exercise of the franchise. And the authority for that is Roach and the Electoral Commissioner, particularly per Chief Justice Gleeson. But there are similar statements that are made in the decision of Rowe and Electoral Commissioner as well. So the conclusion here is that Section 12, I think, would be invalid. Is everyone happy with how we've worked through that? So that is really the level of detail you would need to go into to get a good mark in this unit, I guess. So forgive me if it is a little bit tedious for a Monday night. So now that we've gone through and characterised those provisions, we need to work through the next part of this Act. Okay, so now we need to look at Part 2 of the EFA. And again, we need to ask this same overarching question. We need to characterise it. So is it supported by a subject matter of legislative power in the Constitution? Now, the provisions of Part 2 are very similar, actually, to the provisions in the decision of ACTV and the Commonwealth. And Section 95, capital B in that case in particular. So in Part 2 of the Act, Section 45 is creating an offence. So it creates an offence during an election period for advancing any electoral advertisement that is untrue and likely to be misleading or deceptive. And Section 46 creates a similar offence for election candidates. So the relevant head of power here, I think, would be the incidental legislative power in Section 5139, when construed with all of the provisions that confer power on the Parliament to make laws relating to Commonwealth elections. The creation of an offence like this is incidental to the power to legislate with respect to the election of members of the House of Representatives and the Senate. I should say that this is not what I would call a live issue. I think you could deal with that in a sentence or two. Okay, because there's a much more pressing issue that we need to work through. And you may have already guessed it. But we need to work through the implied constitutional limits, and in particular, we need to work out whether this part burdens, impermissibly burdens, the implied freedom of political communication. So I just want to make it really, really clear. This is very much a formula that we are working through. Okay, these are the key issues that will come up in a legislative power question in an exam. So the overarching issue is always going to be, is there any express or implied limits? And then you need to work out which one it is. It may be express, it could be implied, but you need to be familiar with all of them. So I want to work through this really, really carefully. I want to just give you a little bit of background. I want to reiterate for you how the court actually found the implied freedom. The reason I'm doing this is because I think a good answer in an exam would be able to address at least the nature of the freedom, understand how the court came to find the implied freedom and how it operates. So the implied freedom really has its roots in the decisions of ACTV and Nationwide News. Not Longy. It's not actually got its roots in the case of Longy and ABC. It was first found in the early 90s in ACTV and Nationwide News. It was then refined and limited in the case of Longy and ABC, and that test has since been further refined in the cases of McCloy and Brown. Okay? So hopefully you remember this because, again, we talked about this earlier in the semester. But the way the court found it was, first of all, they found that the Constitution establishes the Commonwealth as a representative government, representative democracy. The court found that representative government was encapsulated in the requirement in sections 7 and 24 that members of the Senate and House of Reps be directly chosen by the people. The court found that this embeds the idea of electoral choice and accountability, and in order to have electoral choice, it necessarily requires a minimum level of open political communication. You might also like to note that the freedom is not confined to an election period, and it's not absolute. And the authority for that is Longy and ABC. It is really important to understand the nature of the implied freedom. It is not a right. It is not a personal right. It is one of the most important implied limits on the legislative power of the Commonwealth and the states as well. The court has conceptualised it as a limit that is necessary to protect the operation of the democratic system in Australia as a whole. Now, the test for whether a law impermissibly burdens the implied freedom, as I mentioned, was first set out really in the case of Longy and ABC. It was confirmed and refined in the decision of McCloy and Brown. So this test, which we're going to apply in a moment, requires a consideration of three broad issues. Namely, whether the law burdens the freedom, you have to go through compatibility testing and proportionality. Now, the significance of the decisions of McCloy and Brown is that the High Court found that when we consider whether the law is proportionate, so when we consider that third element, we need to go through a structured proportionality analysis, which means we need to consider whether the law is suitable, necessary, and adequate in its balance. Okay, and the reason that I've just given you a bit of that overview is I have had quite a few questions that suggest some confusion with how it's developed. So the best way to think about it is the three broad issues were first set out in Longy and refined and confirmed in McCloy and Brown. The significance of McCloy and Brown is the introduction of that structured proportionality. And it's still a bit of a movable feast at the moment. But for you going into an exam, the test that we're about to apply in this question is the test that you would apply if it was an exam. Okay? So we need to work through the first major sub-issue. We need to consider whether there is a burden on the implied freedom. So specifically, do sections 45 and 46 effectively burden the freedom in its terms, operations, or effect? So in the cases of Nationwide News and ACTV, Chief Justice Mason in particular set out an understanding of political communication as including communication about elections among individuals and political speech and discussions from political candidates. Now, importantly, sections 45 and 46 do not directly prohibit criticism of public officials, like the provision in Nationwide News, for example. So if you actually go and have a look at that provision, it's very different from the provision that we've got. But the likely effect of these provisions is that they will have a chilling effect on political speech. The provisions are directed at communication in connection with the electoral process on matters relating to public affairs. So like I said, I think the effect of these provisions is arguably that people will be deterred from voicing their political opinions, or in particular, deterred from criticising government policy or government officials, for fear of incurring a substantial penalty if whatever they're saying may not be 100% accurate. Okay? So I think the freedom is burdened. Is everyone happy with that so far? Can I move to the next issue? Yeah, I'm seeing some nodding for those listening at home. So then we need to consider this next overarching issue. I call this compatibility testing for short, but we need to consider whether the purpose of the law is legitimate in the sense that it is compatible with the maintenance of the constitutionally prescribed system of representative and responsible government. So, again, on the facts of the problem question that we have, the stated purpose of the law is to improve the quality of political debate and discourse in Australia. So with that in mind, Section 45 seeks to prohibit people from publishing advertisements that are untrue, misleading or deceptive during an election period. Section 46 is a bit broader and it does the same thing for political candidates. So arguably, these provisions are aimed at addressing a shortcoming in the political process and a shortcoming in political discourse as well. Like what these provisions are trying to do is ensure that voters are given accurate and truthful information so that they can make a fully informed decision about the candidates that they want to elect. So I think sections 45 and 46 arguably aim to enhance the political process and the integrity of that process and ensure effective representative government. So my conclusion would be that the stated purpose of improving political debate and discourse is not only compatible with representative government, but it actually enhances it. So I think this would be a legitimate purpose. Is that all right? Does anyone need me to repeat anything? You're okay? Okay, I'll move on. But the next issue, and this is the big one, this is always going to be the big issue. We need to consider whether it's proportionate, which means we have to go through these sub-issues of suitability, necessity and adequate in its balance. What I'll do, I'm just going to go to the next slide if that's all right, because, I mean, I've got the law for you on that slide. I actually want to go through the application of it in some detail. So I think in terms of the suitability, what we're looking for with suitability is a rational connection between, in this case, the prohibition on making statements that are untrue or misleading or deceptive, and the purpose of improving the quality of political debate and discourse. And I think there is a connection here. I think that's a fairly logical relationship there. But my concern is more about the necessity point. So for Section 45, it's a bit better than Section 46. So hopefully if you looked really closely at the facts, Section 45, this prohibition only applies to electoral advertisements, not to communication generally. It doesn't discriminate between classes. But it applies equally to individuals, political parties, candidates, groups. It applies to everyone. It doesn't discriminate between classes of people. Furthermore, and significantly, it contains a defence. Okay, so it contains a defence in Section 45, subsection 2, and this is just reading from the facts. So where a person did not know or could not reasonably be expected to have known that the advertisement was untrue, misleading, or deceptive. This is a really relevant fact for you if this was an exam question, because that actually suggests that Section 45 may satisfy the necessity requirement because there is that defence. In contrast, Section 46 is much, much wider than Section 45. So it applies to statements generally. It doesn't just apply to advertisements, it applies to statements. And there's no defence. So I think that it is doubtful whether Section 46 would satisfy necessity, because I think it could be limited in the same way that Section 45 is. So it could be limited to advertisements during an election period, and it could contain a similar defence. We also need to consider the question of balance and what we're doing when we're considering this third aspect of structured proportionality. We're balancing the public interest in free political communication. Okay, so there's a public interest in free political communication against the competing public interest that this restriction is designed to serve, and that is the improvement of political debate and discourse. So I think the relevant facts in weighing up this element, and I think this is the toughest element to satisfy with our facts, because I think it's relevant that the restrictions in both sections 45 and 46 are difficult to implement. There are no legally discernible criteria about what is untrue, misleading, or deceptive. It's quite subjective. And furthermore, I think both of the provisions, at the end of the day, they're going to have a chilling effect on speech. And what I mean by that is it's basically going to silence people, I think. People will be scared to voice their views. So these are restrictions of a nature that Chief Justice Mason referred to in ACTV. So they're restrictions that affect free communication in the conduct of elections for political office, and for it is in that area that the freedom of political communication fulfills its primary purpose. I might just say that again for you. So these restrictions in sections 45 and 46 are of a nature that Chief Justice Mason referred to in ACTV, namely, they're restrictions affecting free communication in the conduct of elections for political office, and it is in that area that the freedom of political communication fulfills its primary purpose. So I think these provisions, I mean, it's arguable. I think the better conclusion would be that that Part 2 is probably going to impermissibly burden the implied freedom. I'm not convinced that there is a reasonable justification for the extent of the restrictions imposed by sections 45 and 46 of the EFA. However, as I've said through the whole unit, the conclusion, it's good to have it in a sentence. Doesn't matter what conclusion you come to. Like I said, a really good answer would step through each of those elements, sort of as I've just done, and apply the law to the actual facts and really engage there. And I think because this factual scenario is very analogous to ACTV, so again, remember to have a look, at least be familiar with those cases. ACTV, Nationwide News, Longy, McCloy and Brown, right? They're your key cases. Does anyone have any questions on that? Are you happy with how I've worked through that scenario? Okay. I'm seeing some nodding, so I'll move on. And we do have still quite a bit to cover. So There is another issue in this massive factual scenario, okay? So this is what you can expect to get in an exam, okay? It's a really good example of an exam question. The next issue we need to look at is actually something we haven't looked at yet. We're looking at judicial powers. So the issue is, it concerns Part 2 of the Act and the establishment of the Truth in Political Speech Tribunal. Now again, if you're in an exam, the establishment of a body like a tribunal should be a red flag to you that that is a judicial power question. This is particularly a question about the separation of judicial and non-judicial power at the Commonwealth level. So when you're looking at a judicial power question, there are really some main overarching issues that you need to consider, and we're going to work through them, but they are as follows. The first thing you need to do is work out, is the power conferred by the Act judicial or non-judicial? That's the first thing you have to do. The second thing you then need to work out is whether the legislation infringes any of what I call the prohibitory rules. I'm going to go through them in a moment. And then you need to work out whether any exceptions to those rules apply. Okay, so as we move pretty carefully through this part of the tute, just stop me if there's anything that you don't understand, because it's the first time we've looked at separation of judicial and non-judicial power. So let's consider the first issue. So the first thing we need to do, like I said, is we need to work out whether the power is judicial or non-judicial. And in order to do that, need to go through these sort of criteria or elements of judicial power that were set out by Chief Justice Griffith in the famous case of Huddup, Parker and Moorhead. So the elements are, there's got to be a binding and conclusive decision. There has to be a controversy. What I mean by that is the High Court, our High Court in Australia, can't give opinions. Okay, so there's got to be a dispute between two parties. Has to concern existing rights. It can't be a decision that creates new rights. And it has to be according to law and in a judicial manner. What that means is judges need to consider the law, first of all, and then the process has to meet the requirements of due process. So let's work through this, having a look at sections 45 and 46. So we are told, the facts of the problem tell us that the tribunal is empowered to hear complaints under the provision. So there is nothing on our facts to suggest that the proceedings can be initiated by the tribunal on its own motion or anything like that. So if you had a fact that said something like the tribunal can on its own motion do this, that's not a dispute, that's not a controversy, okay? Can't do that. Seems to involve the application of pre-existing set of rules or standards. It's set out in the legislation. And it confers power on the tribunal to impose a conviction or monetary penalty for non-compliance. So that's fine as well. So we don't have any facts to suggest that the decision is not conclusive. So a fact that you might look for in that sense would be something like if the High Court could conduct a complete review, or the tribunal, sorry, could conduct a complete review of evidence, which is fact, as well as a complete review of the law. Something like that might suggest that it's not a conclusive decision. It could amount to what we call a de novo rehearing. But we've got nothing on those facts to suggest that. So I think we can safely conclude that what sections 45 and 46 are doing is they're vesting the tribunal with judicial power. And again, I actually think if that was an exam, you could move through that quite quickly. I don't actually think there's an obvious issue in dispute there. But that's not where we stop, okay? So we've got judicial power. If we continue reading the facts, there is one fact that's a bit of a concern, and that is it says quite expressly that the tribunal is to have regard to the law, so that's a plus, But it also goes on to say that it can have regard to the conventions of political campaigning and the broad public interest. And furthermore, the members of the tribunal are not actually required to all have legal qualifications. So what that part of our factual scenario tells us is the Act is actually trying to confer some non-judicial power on the tribunal as well. Okay, so that's the first issue that we've worked through in a judicial power question. Having established that the Act confers judicial power, also non-judicial power, we need to turn to our second issue and ascertain whether the legislation itself infringes any of the prohibitory rules. So really there are two main prohibitory rules. So the first one, so judicial power can only be vested in a court which is correctly constituted under Chapter 3 of the Constitution, and in particular Section 72. We call it a Chapter 3 court. The authority for that is Alexander's case. The second rule is that federal judicial power can only be vested in bodies which are exclusively judicial in function. What that means, put really simply, non-judicial power cannot be vested in a federal court. And the authority for that is the famous decision, it's the Boilermakers case. These rules reflect the very, very important principle of the separation of powers in the Australian Constitution. Separation of judicial and non-judicial power is so important in our system because we have that Westminster system where our executive is drawn from the Parliament. That's why the court has been so strict on maintaining basically the judicial independence of the courts, because it's the courts that provide that really important check on power. So in working through these two rules, and they are really important rules, the first thing we need to work out, well, is this tribunal correctly constituted under Chapter 3 of the Constitution? Okay, so the Act establishes this tribunal. It's a decision-making body empowered to hear these complaints. An implication can be drawn from Section 71 of the Constitution that only Chapter 3 courts exercise judicial power. The relevant facts for us, the members of the tribunal, other than the chair, are appointed for limited 7-year terms, and they do not have appropriate security of tenure that is required by Section 72 of the Constitution. That does not meet the standard of a Chapter 3 court, and the authority for that is Alexander's case. So any attempt to vest judicial power in the tribunal will be unconstitutional. So I just want to pause there. Do you see why it's so important to first of all figure out if there is judicial power in the first place before going through and figuring out whether the tribunal is a Chapter 3 court? The next broad prohibitory rule comes from the Boilermakers case. So remember, we concluded that this Act also attempts to vest the tribunal with both judicial power and non-judicial power. Do you remember that was because it doesn't just deal with law, it deals with these political conventions as well. So this is unconstitutional. That is unconstitutional pursuant to the Boilermakers case. I'd love to give you a summary of that case. I just unfortunately don't have time tonight. Okay, but please understand the principle that comes out of that case. So this is unconstitutional as well. Okay, so we've gone through the two main prohibitory rules, and at the moment the Act is in real trouble here. The next issue that you need to work through is whether there are any exceptions that might apply. And there is a relevant exception. There is an exception. Non-judicial powers may be exercised by federal judges in their personal capacity. This is known as the persona designata rule. Non-judicial powers can be exercised by federal judges if they consent to the appointment. The authority for that is Hilton and Wells. We do not have any facts to suggest otherwise, so I think that would be okay. The next issue is the function has to be compatible with the judge's capacity to perform his or her judicial functions, taking into account the time required and the nature of the role. And the authority for that is Grollo and Palmer. So if this non-judicial role could undermine public confidence in the judge's independence, the delegation will not be allowed. And on our facts, because the federal court judge is just the chair, it doesn't seem to be a full-time role. So I think this judge could still perform his or her primary function as a judge of the federal court. So I think that would probably be okay. But I still think that this piece of legislation has some real problems from the separation of powers point of view. Before we move to question 2, I do just want to pause. Do you understand the way that I've worked through those 3 issues? So that is the method you'd need to go through in an exam. The questions that I'm asking you are the key issues that come up in the cases. That's why I say that these are your frameworks, if you like. So that's the way that you work through these types of questions. I am going to move straight to question 2 before we take a short break, if any break, if that's all right. Okay, so I'm going to move a little bit more quickly through question 2 for you. But again, we're starting with the same overarching issue because we've got legislation again. So what we're asked to consider is the constitutional validity of a Commonwealth Act and 2 Queensland Acts. So if you had a question like this in the exam, the logical way to proceed is to go through each piece of legislation individually. So let's begin by considering whether the Commonwealth Act is supported by a subject matter of legislative power in the Constitution. So Section 4 makes it basically an offence to engage in a terrorist act. So these words like terrorism or things like mild international uncertainty, they're the facts that you need to look at that might get you thinking this could be a defence question. Okay, this is a defence power question. So the first thing you would note if this was an exam question is that the defence power extends to internal threats. The authority for that is the case of Thomas and Mowbray. The court held there that the protection of the Commonwealth from terrorism falls within the central conception of the defence power. Now, I want to just use this opportunity to just give you a little bit more on the defence power because this, some of my other tutorials have asked if I could do that in this session. So remember, the defence power is different from the other heads of power because it's purposive in character. Again, if this was an exam question, you need to note that. That's a really important distinguishing factor for the defence power. Because that means we need to use that proportionality test to assess whether there is a connection between the measures in the legislation and the purpose of defence. Also, the treaty aspect of the external affairs power, so think back to external affairs, that's also purposive because remember we need to assess the connection between the convention or the international agreement and the legislation that purports to implement it. So these both have purposive aspects to them. So what that means when we're looking at a defence power question, the key issue is going to be, is the creation of this offence in Section 4 reasonably appropriate and adapted to the purpose of defence? And remember, what is appropriate and adapted to the purpose of defence will differ according to the actual circumstances of the time. Okay, so in wartime, the defence power will support a much wider range of activities than it would in a time of relative peace. And even if it's mild international uncertainty, that's still relative peacetime. That's not the same as actual wartime. Okay, we haven't had wartime in Australia for a very long time. So on our facts, it would appear that although there are international tensions potentially, the defence power is operating in a time of relative peace. It would not be operating in that wider secondary sort of aspect. The overarching purpose of this Act is to protect the public and world leaders who are attending the G20 from a terrorist attack. That's the purpose of this legislation. Section 4 helps to achieve that purpose by making it an offence to engage in a terrorist act that is sufficiently connected to the purpose of defence. The provision is specifically aimed at the protection or defence of the Commonwealth. So it would be supported by the defence power, and in fact, that would be where you would start, okay? The defence power would be the logical head of power that you'd go for. A really good answer would note briefly and only briefly that this provision could potentially be supported by the legislative nationhood power. However, I think it would be safer to rely on the defence power because, remember, since Thomas and Mowbray, the court has held that the defence power extends to internal threats. This implied nationhood power, these cases are really old. They are well and truly before Thomas and Mowbray was decided. Okay, so the expanded interpretation of the defence power as set out in Thomas and Mowbray has sort of really relegated this power to secondary importance. Does that make sense? So it still exists, but it's not really necessary anymore because of the way the courts interpreted the defence power. Okay, so that's Section 4 of the Commonwealth Act. I now want to have a look at Sections 11 to 16. So these are procedural provisions that apply where a person has been charged with an offence under the Act. The relevant power here would be, again, the incidental legislative power in Section 5139, when read with Section 77, subsection 3, confers power on the Parliament to make laws affecting the trial of federal matters. So under Section 77, subsection 3, the Commonwealth Parliament has power to confer federal jurisdiction on state courts. However, unlike federal courts, state courts are not created by the Commonwealth Parliament. The reason I'm saying that is it means that there are limits as to what the Commonwealth Parliament can do with state courts and the jurisdiction that belongs to them. I want to work through each of these provisions fairly quickly. Again, this is the logical way to work through a question like this if it was an exam question. So Section 11, it says the Commonwealth Parliament has power to vest jurisdiction in state courts under Section 77, subsection 3, or territory courts under Section 122. Okay, so this is not a live issue here. We do need to consider whether the power is judicial in nature. So we went through those key elements in question 1. Most relevant here, Section 4 clearly involves the application of that pre-existing set of standards. What it's doing is it's setting out criteria that must be met for when a person has committed an offence, and it confers power on the court to adjudge and punish criminal guilt. So that is essentially judicial in nature. And the authority for that is Alexander's case and the industrial lighting case. So again, there's not a live issue in dispute there. That's clearly an exercise of judicial power. Section 12 simply restates the effect of Section 109 of the Constitution. This type of provision evinces a clear intention on the Commonwealth's part to cover the field. So you might cite authorities like when an Attorney General, we talked about University of Wollongong and Macwally and the same-sex marriage case last week. Sections 13 to 15 are very, very interesting. So what these provisions are doing is they're trying to regulate the procedure of state courts where federal jurisdiction is vested. The general rule is that when the Commonwealth Parliament makes a law investing federal jurisdiction in a state court, the Parliament must take the state court as it finds it. It was put another way in the decision of Forge and ASIC, that's F-O-R-G-E, and ASIC, the Australian Securities Investment Commission. In that decision, Justices Gummow, Hayne and Crennan explained that the provisions in Chapter 3 of the Commonwealth Constitution do not give power to the federal Parliament to affect or alter the Constitution or the organisation of state courts. I hope you're seeing this is a federalism issue here. That's really what it is. So the main issue, as I've reproduced on the slide for you, the main issue we need to work out is whether sections 13 to 15 require or authorise a court to act in a manner that is inconsistent with procedural due process, which means you need to have a look at the statement of Justice Gaudron in Nicholas and the Queen, which was adopted by the majority of the court in Bass and Permanent Trustee Co. I don't have time to go through these cases, but they're extracted at pages 438 to 9 of your textbook. So in looking at the closed court requirement in section 13, you might draw an analogy with the decision of Russell and Russell, particularly per Justice Stevens' judgment in that case. So really quickly, that concerns section 97 of the Family Law Act, and it provided that proceedings be heard in a closed court. Majority held that was invalid. So similar reasoning could be applied here. There might be some argument on our facts for excluding someone who doesn't have an appropriate security clearance because of the nature of the subject matter. It does involve national security. However, the fact about the exclusion of the accused from the court is going too far. Section 14 prohibits cross-examination. That is also likely to be a breach of those Nicholas limits. So what those Nicholas limits are concerned with, it's due process. So prohibiting cross-examination could interfere with due process. Section 15 would be okay because the Commonwealth does have power to make laws relating to the burden of proof, as long as the court is left free to impartially find facts and apply the law. And Section 16 imposes a mandatory minimum sentence. In Magaming, the court held that that was not inconsistent with the institutional integrity of the courts. And it does not involve the imposition of an arbitrary sentence. Okay, so that's the first piece of legislation. That's the Commonwealth Act. They're the issues you would need to work through. We've still got 2 pieces of state legislation to go. Again, if this was an exam, start with the Commonwealth legislation and just work through each individual bit of legislation. Try not to get too overwhelmed by facts. So the next issue you might need to work through, you do need to work through, is whether the Queensland Parliament has the power to enact the G20 Public Harmony Act. So again, in an exam, if you see state legislation, if you see the words QLD or New South Wales or WA at the end, you know that you can deal with that really quickly. The states have plenary and ample legislative power. That's not going to be the issue in dispute. The issue is going to be, are there any express or implied constitutional limits that are going to apply to that legislation? And on our facts, the issue is whether this Act impermissibly burdens the implied freedom of political communication. So I've put this slide up. I'm not going to go through it again because I've already gone through it in question 1, but to get a really good mark, you need to demonstrate your understanding of the source of the implied freedom and the nature of it. In particular, because you're dealing with state legislation, you need to state expressly the implied freedom, it extends to state laws. The authority for that is Stevens and West Australian newspapers and Coleman and Power. Okay, so it doesn't just operate to limit Commonwealth laws, it operates to limit state laws as well. And it is not confined to election periods. Like I said at the beginning of the tute, I'm not going to go through this in detail again. We have just done an implied freedom question. Here there would be a burden, again, because what it is effectively doing, it's going to deter people from protesting about broadly political issues. So issues about the national economy, the global economy, the G20, potentially participants of the G20. So there will be a burden here. In terms of a legitimate purpose, I think part of the Act is certainly legitimate. There is a public safety element here. But there's also a fact that says the avoidance of disruption to the G20 summit. Arguably, that is not a legitimate purpose because that seems to be going more to the prevention of protests about the global economy or G20. So I think that would actually quite severely limit the implied freedom of political communication in a way that's not compatible with representative government. I think you could apply the reasoning there in the case of Brown and Tasmania. And similarly, with proportionality, the buffer zone itself, the existence of a buffer zone around the buildings where the meetings are being held, there's a rational connection there between particularly the purpose of public safety, I think. But there could be an argument that 500 metres is a bit excessive. So the Parliament could consider decreasing the buffer zone, or alternatively, maybe request that people obtain maybe some kind of licence or a permit rather than prohibiting protests altogether. In terms of balance, I think, again, you might want to compare this piece of legislation with the Protesters Act in Brown, which the court held as being disproportionate to the purpose. So in that case, there was some uncertainty about the areas within which the Act applied. The same could be said here. So there's any venue or location where a G20 meeting is being held. Okay, so I don't know how much you know about diplomacy, but this includes those really big meetings, but there are a whole heap of bilateral meetings as well. I think it'd be really difficult to know where those meetings were, unless it was a really clear map or something like that. So you might want to draw a loose analogy with Brown there. In Brown, though, there was evidence of other legislation that was in existence. We don't have similar facts on our problem scenario. What is significant, though, is that these were the types of factors that the court took into account in applying the proportionality test in Brown. I'm sorry I can't go through that in more detail, but I do just have to move on. The next issue, there's another piece of legislation that we need to consider, and it's the Public Safety Act. Again, your starting point is always going to be the states have plenary and ample legislative power. That will not be the issue. The issue, again, is if there's an implied constitutional limit, and here there is a really, really important one. Haven't had the chance to talk about it, but I need you to go and get familiar with the Cable Doctrine. It's really important. So we need to consider whether this Act contravenes the Cable Doctrine. The main issue is whether this Act is inconsistent or incompatible with the institutional integrity or judicial independence of the court. So hopefully you remember, so there's a really strict separation of powers at the Commonwealth level. Okay, there isn't the same at state level. So that's why we have the Cable Doctrine. So what the High Court has done is it's extended the reach of the Commonwealth Constitution to the states, which means that there are some limited constitutional protections that exist for the independence of state courts. So what the Cable Principle does is it prevents clear and severe intrusions into the independence of the judiciary. However, it's only really been applied successfully a few times. So it's sort of had mixed success in placing limits on executive capacity to interfere with the decisional independence of state and territory courts. Please go and read the decision in Cable. It's a very, very important decision, and it is on your key cases reading list. You also need to be familiar with the way it's been applied as well. Okay, so it is a really important principle, and I wish I had another half an hour to talk about it, but I just don't. Instead, I'm just going to apply the principle that came out of Cable to this factual scenario. The issue is, are continuing detention orders inconsistent or incompatible with institutional integrity? So the facts that are relevant here, the orders are of a general application. They're not aimed at an individual. So you would apply the case of Farden, which was decided after Cable, but contrast it with Cable. Okay, it's different. There's nothing on our facts to suggest that the ordinary judicial processes have been undermined. So you might cite the cases that I have on the slide. So Wynahoo and New South Wales, Gypsy Jokers and K-Generation, they're all the bikie cases. But you would contrast it with decisions like International Finance Trust and South Australia and Tatani. Okay, so you might want to be familiar with at least the facts of these cases and how the Cable Principle was applied. So basically the Cable Doctrines broadly had mixed success, I guess. Following the decisions of Tatani, Wynahoo and cases like Pompano as well, what the states have done is they've tried to ensure that their legislation confers sufficient discretion on the courts when issuing control orders. So that's sort of a good thing, but at the same time, at best, it's a very thin conception of the rule of law that's protected by the Cable Doctrine. Okay, look, that's all I have on the substance of this tutorial. Please accept my apologies again for how quickly I've had to work through that, but I wanted to cover all of the issues for you in the lead up to the exam. I'm going to spend the next 5 minutes, 5 to 10 minutes, for those of you who can stay, on hopefully helping you figure out this whole unit. So I want to bring you back, and if you have it on your screens, for those listening at home, if you can get up your learning resources on Blackboard, might be helpful for you. So I just want to reiterate that what we're doing in constitutional law, what the Constitution does, is it confers power on the branches of government and it limits it. That's what we're doing here. We're looking at the conferral of power and constraints on power. The Constitution separates power horizontally. It does that by vesting powers in different branches of government. It vests it in the Parliament, the Executive, and the Judiciary. Our Constitution also separates power vertically. We have a federation, so the Commonwealth has certain powers and the states have certain powers as well. So it's a vertical separation of powers. There are also principles like representative government and responsible government that ensures that governmental power at all times is exercised by people who are accountable to us. And we can vote people in and out, and that's a really important part of a democratic system. So the main task in this unit, the main task of constitutional lawyers, is we need to work out that the government actually has the power to do what it wants to do, that it's not overstepping its constitutional boundaries, because we have rule of law in this country and constitutional supremacy. So, bearing those broad ideas in mind, I just want to talk you through this outline. So, the first 3 weeks, we are looking at the general principles of constitutional law, things that I just mentioned then. What underpins the whole document? Here in green, what I've put up in green, this is your legislative power, okay? This is Chapter 1, the Parliament. These are the topics that the Parliament can legislate with respect to. These are subject matters in Section 51. So what that means is if there is an act of Parliament on your factual scenario, you need to characterise it falling under one of the heads of power that we've looked at in the unit, and we've focused on a few of them. So you might be looking for words like terrorism to alert you to a defence question, or a convention for external affairs, or a fee for a tax, or the word trading corporation or financial corporation for corporations, or citizenship for aliens and immigration, or maybe the law's aimed at a class of persons, which makes you think about the race power. They're the types of things you need to look at. Importantly, each head of power has different issues. And that's what we work through in the tutes. We work through what the High Court has told us are the important issues in each power. And that's what you need to be familiar with, and that's what I mean when I say put a framework together for each power. Each head of power has different issues that the court will consider. There's no one-size-fits-all approach in this subject. So I think the best way to prepare for your exam is maybe to structure your notes around those key issues that come up under each topic. That's going to be the best way to go about it. And remember, even after you've successfully characterised a law as being with respect to one of these subject matters, you still need to consider whether any express or implied constitutional limits apply. Okay, so even though it may be valid under Corporations Power, if it infringes the implied freedom of political communication, it can still be invalid. So that's the approach for a question that involves legislation. If there was a factual scenario where there's no legislation, you might be thinking this could be an executive power question. We looked at executive power particularly in the context of spending and grants to the states under Section 96. And I've highlighted that in blue for you. That's Chapter 2 of the Constitution, dealing with the executive. The third chapter of the Constitution is the court. It's the judiciary. And I've highlighted that for you in purple down the bottom. We've looked today at the separation of judicial power at both Commonwealth and state level. Okay, that's Chapter 3 of the Constitution. In addition to that, in red, I've highlighted these are the express limits that apply. You need to understand the express limits on legislative power, as well as the implied limits like the freedom of political communication and the franchise that we've looked at today as well. And then finally, in pink, I've highlighted the states. We looked at where there's inconsistencies between the states. That's federalism in practice right there. And that's the way the unit has been structured. I should caveat, remember section 92 is another one of those express limits. That applies to both the Commonwealth and the states. But I just wanted to make that really, really clear for you. That's how the unit fits together. Okay, so you just need to separate it out. So green, that's your Parliament. That's what the Commonwealth Parliament can do through legislation. In blue, that's when there's no legislation. That's when the executive is just acting. They're just handing money out to taxpayers, if you're around in 2009. The purple is Chapter 3. It's judicial power. Different issues again. And then you've got to go through your limits and be familiar with the states. Okay, so that is actually how we've structured the unit. I hope that makes a little bit more sense, perhaps, and ties it together for you. I know I'm really, really tight for time right now. I do have a few tips that I would like to give you for the exam, because it is the last tutorial, and I hope you can learn from my many and varied mistakes at law school. So I've split this slide up for you into different stages. Okay, so revision is obviously your swap back, perusal, writing time. I've done that because, I don't know, I think it's helpful. So I think the most important point for you right now, at this point in the semester, is getting your notes together. At the end of the day, it is an open book exam. You've got to get notes together that work for you. The reason that I just put up the sort of overall learning resources is I'd be structuring your notes according to that. I think that's going to make sense, and I think the best way to have your notes is according to the issues that are going to come up in a problem-type question. Having said that, I also strongly recommend that you have a look at the discussion board for those broader contextual essay-type questions as well. Okay, so don't forget the discussion board. Practice exams, I think, are the most effective way to grapple with the material, because I think the hardest, and I've said this a few times, the hardest thing in this unit is spotting the issue. Practice exams will help you do that. The teaching team can't look at your answers, but we've actually got the feedback released for you. It's on Blackboard, it's under assessment, final exam, there's the past exams and the answer guides as well. And where you can, study in groups. It's more fun. It's much more fun, and you can bounce ideas off each other as well. I really mean that as a piece of advice, because that's what got me through. Anyway. When you're in perusal, so the most important thing for all of you, for those listening at home too, read the question more than once. Do not just read it once. You'll be a bit anxious. There'll be a lot of adrenaline. I used to minimum 3 times. I wouldn't write a thing in perusal until I'd read it 3 times, because only then you'll start to see the issues and you'll start to calm down as well. Okay, so read it more than once. Plan your answer. Just put a few dot points down if you feel like it. But the most important thing I did is apportion time to each question. So the most heartbreaking thing as an examiner is when a student has run out of time and has missed a whole question. So think of it like this. At the end of the day, you can only get a set amount of marks for each question, right? Apportion your time according to the marks that you've got. The way that I would do it is actually in perusal, I would work out the actual time it would take for each question depending on the marks, and I'd actually look at my clock and put down a time when I knew I would have to move on to the next question. So in perusal, I would say, at 9:15, I have to be moving on to question 2, and so forth. It stopped me having to calculate it when I was trying to write an exam. It meant that I never ran out of time. Okay, so that's the most important thing. Do not run out of time. We can mark something that's on the page. We can't mark what's not on it. Okay, so don't be tempted to just go, I don't know about question 3, I'm just going to do these ones really well. You can only get so many marks for those ones. Okay, so just bear that in mind. That's really, really important. And actually in the exam with writing time, so everyone says use time wisely. So some ways that you can save yourself some time, abbreviate things. You don't have to write out the whole case name, okay? So use abbreviations, use CWTH instead of Commonwealth. Do not write out sections of the Constitution. You won't get marks for stuff like that, okay? So that's what we mean when we say use time wisely. And remember to always cite your cases and your constitutional provisions as well. Okay, well, I think I am out of time. So thank you so much. And for those listening at home too, for a great semester. Good luck. And can I just remind you, if you have a moment, please fill out the teaching survey if you can. It'd be really good to get your feedback. I've really enjoyed taking this class. So good luck, everyone. And I might see you at the final exam.